Okay, calling number 12, Attar versus Tollgate, Mr. Nelson.
Thank you. To please the court, Mason Nelson on behalf of the petitioners. The two issues on which this court grants certiorari are present in every contested special exception case in Maryland. The neighborhood issue, whether the tribunal has the obligation to define it. Some jurisdictions define it, others do not. The burden of proof question is an intractable problem that is confronted in every contested case. When one reads the special exception jurisprudence, you see language to the effect that the applicant has the burden of proof. Then you turn the page and you see a sentence that has the phrase or the word presumption in it. And that dichotomy, I respectfully suggest, is the cause of this great uncertainty at the administrative level as to how one deals with the burden of proof. And the reality, of course, I have a perspective. I represent citizens in these cases, and perhaps my adversary has a different perspective. But my perspective is that the tribunals see the word presumption, and the de facto reality is that that shifts the burden to my clients, the protestants. When we believe under the law, the burden remains with the applicant. I think it's, I've written so many of these briefs and thought about this issue so much. It's so easy to lose sight of what it's like at an administrative hearing. Often these are hearings at night at the end of a workday for lay members of a zoning tribunal. Often they don't have counsel advising them. Some counties do, others do not. There's a lot of turnover on these tribunals, and there's lots of confusion. I was involved in a protracted special exception battle in Charles County, and we're debating night after night. Schultz, and these are code words for us. Loyola, another code word, and one of the board members, who's a man of good faith, who wanted to do the right thing, was working hard, said, and understand, these are hearings that are going from 7 p.m. to 10:30 p.m. at the end of a workday. Everybody is exhausted. And he says, I've tried to read Schultz, I've tried to read Loyola, and his point was, well, what do they mean?
Mr. Nelson,
yes, sir.
On the issue of the burden shift, the Court of Special Appeals addressed that issue, and they felt that the burden did fall on the applicant and that there was not a shift here. Can you address what the Court of Special Appeals held in the case?
The court did say that, and of course we're looking through the Court of Special Appeals, we're looking through the circuit court, we're looking back at the board's decision, and I respectfully suggest that the Court of Special Appeals erred when it reached that conclusion. I direct the court, Judge Getty, to extract 542 and 543. These are the key pages of the board's decision. This is the decision that is before this court today, not the Court of Special Appeals decision. The board summarizes the Baltimore County Ordinance, Section 502.1, talks about that there's a presumption under Maryland law that a special exception is in the general interest of the jurisdiction and therefore valid. These are the board's words. Then the board says, quote, the protestants' concerns taken from the available evidence do not rebut the presumption of validity of the special exception used in this case. We assert that the board erred when it shifted the burden to the protestants. That we also, if the court is interested in my views on the Court of Special Appeals opinion, the court erred. I think they got it wrong. This is one of the reasons why I think that Judge Murphy's concurrent opinion is so helpful, and this is why I drafted the cert petition the way that I did. We know that the Schultz assigns the burden to the protestant. We know that Loyola cites the Easter case for the proposition that the burden is on the applicant. And this case presents this court an opportunity to reconcile those statements in the law with the use of the word presumption in these cases. And I must say that People's Counsel, I think, did a very thorough job explaining the origin of the word presumption. Traces this court's use of that word from the Merlin's case, I think 1953, through the present, and the brief speaks for itself, but the history conveys the message that the first time this court used that word in the Merlin's case, it used it in the context of distinguishing a special exception, which is on the list of uses allowed by special exception so long as there's no especially adverse effect, distinguishing that from a variance. And then over time, People's Counsel explained very thoroughly as to how, in some of the more recent cases, it looks like there's a presumption in favor of the special exception, when in fact there is not. But I think that Judge Murphy's concurrent opinion in Loyola is very, very helpful, because it reconciles the burden of production with the burden of persuasion. It reconciles the assertions that the applicant has the burden of proof. It gives respect to the notion that a special exception is on a list of uses allowed so long as there are no especially adverse uses. And what does he say? And then he uses language that every lawyer and every trial court, every appellate court uses. He uses classical summary judgment language. Is there a genuine question of fact? So what Judge Murphy is saying is that if and I'm talking about a contested special exception case. Now, if an applicant comes in and presents and meets his burden of production and lays out his prima facie case for a special exception, and if the protestant offers evidence on issues which create a genuine issue of fact, Judge Murphy says the applicant has the burden of proof. And in this case, we presented three areas of question of fact, and the subtleties of the question of fact aren't central to this opinion, but they appear. We summarize them at pages 13 through 15 of our opening brief. Basically, they have to do with traffic congestion, and if the court wants to get into the nuances, I can. The questions of fact about the effect of the Gwynns Falls stream and the floodplain, and the questions of fact about the economic stability. So I think under any analysis, there was a genuine question of fact on those issues. I'm not saying that we automatically win because of that evidence. What I'm saying is a question of fact on those issues, and because there's a question of fact, the board was required to explicitly assign the burden to the applicant, and the board erred because it assigned the burden to my clients.
Counsel, the Court of Special Appeals made the point that the statement about the presumption was taken out of context in the board's opinion, and that in other instances the board did assign the burden. For example, on page 542 of the extract, the board wrote, "The instant case then presents the narrow issue of petitioner's compliance with the requirements for a special exception. In the board's view, the evidence presented is sufficient to satisfy the requirements of section 502.1, which indicates that the board was aware of the petitioner's burden." Can you comment on that and the general observation of finding by the Court of Special Appeals that the presumption comment was taken out of context?
I think the Court of Special Appeals erred again. I think what really happened is that the board, people of good faith, people who are trying to do the right thing, people who are not land use lawyers, people who don't have the advice of a lawyer experienced in these matters telling them what the law is, they look at the presumption, they say the protestants didn't rebut the presumption, and so now what they're saying is, because my clients didn't rebut the evidence, because my clients failed to meet the burden of proof, the evidence was sufficient to satisfy the requirements of 502.1. I think that's what happened, you know, so I don't think there's any fair reading of this board's decision which allows one to say that the board did not assign the burden to the protestants. I think the protestants' concerns taken from the available evidence do not rebut the presumption of the validity of the special exception used in this case. I don't think it can be any more clear than that. And we ask this court to adopt the Judge Murphy concurrent opinion as the way to evaluate the burden of proof. I think that such a rule will streamline these special exception cases, will reduce the number of appeals that we see in the Court of Special Appeals and perhaps in this court, and will help all of us process these cases fairly and economically and efficiently.
You seem to take issue with whether or not there was I'll call it a working definition of the neighborhood. And we know that Schultz discussed the definition of a neighborhood insofar as a special exception is concerned. But in Alviani, we expressed or we injected what we call flexibility relative to the definition of a neighborhood. Could you speak to that? Because if you still are at issue relative to whether or not they define the neighborhood in the appropriate terms.
Oh, I'm still there. The reason I did burden was Judge Eddy asked about it, and I intended...
No, I understand.
Yeah.
No, I understand. But my question is not focused on the burden part.
Okay.
I'm on the neighborhood now.
Right, well, good, because that's, I'm there too, right with you. Alviani, of course, is a variance case. This is a special exception case. That's just one point. There was a description of the neighborhood in Alviani. I'm looking at page, I'm at the A2nd site, 775 A2nd 1247. They talk about how the neighborhood was defined. But let's turn to our case. We know that the notion of a neighborhood is a central concern in a special exception case. You read Schultz. Schultz talks about whether there's a detriment to the neighborhood. You read, if you go to Loyola, this was very interesting. Actually, I went to Loyola and I did a word search for the neighborhood, and it reviewed it was one of Judge Harrell's opinions, you know. But it was informative to me as to how much of a presence in the special exception jurisprudence the concept of neighborhood is. And then in the Zimmer case, just note 17, notes that a fact finder in a special exception case, whether the use would result in an adverse effect on the neighborhood. So whether there's an adverse effect on the neighborhood is central to the special exception case. And what's so fascinating is you read all these special exception cases, no one has ever confronted the question of whether there must be a definition of the neighborhood. I think it's implicit in this special exception jurisprudence. And the other interesting thing is when you read this court's rezoning jurisprudence, for some reason that issue has been developed. And there is a requirement in a rezoning, piecemeal rezoning case, that the neighborhood be defined. Rollins talks about the need to define a well-defined area, which Judge Harrell calls the neighborhood.
But a rezoning case is a much more, let's say, drastic action than the granting of a special exception. Would you agree?
I would say that it should be tougher to get a rezoning than it should be to get a special exception, if that's what you're on.
I accept that rewording.
I'm sorry?
I accept that
Yeah.
rewording.
So, rezoning cases should be tough to get. The question, I think, implicit in your question is, well, is that a reason to require a definition of neighborhood in a rezoning case, not a special exception case? Maybe. But here's why I think the answer is no, is that you look at Schultz, you look at Loyola, you look at Rohellen,
The specific delineation of a neighborhood is not always an easy task. Agreed?
I think there can be differences of opinion on what the boundaries of the neighborhood, but the court in the rezoning jurisprudence has laid out the principles. You look at topography, you look at natural features, you look at the road. Neighborhoods in a rural area may be larger than they are in an urban area. I don't think...
But if the special exception case doesn't present an issue that requires exact delineation of those boundaries.
May I explain why?
Should we, just a question, should we be imposing upon these boards the requirement to delineate specifically where the neighborhood is?
Here's why I think yes, and here's why I think it would be helpful. In a special exception case, there's debate about whether there's going to be an especially adverse effect on the neighborhood. Well, if there's a definition of the boundary of the neighborhood, that limits the geographical area in which the board will consider the adverse effect. I think it will streamline the process. I'm not saying you have to do a GPS boundary of the neighborhood, but you need a general, reasonable description of the neighborhood. And I don't think that it's we cite the law in our brief about the rezoning, where we talk about all the different ways in which to analyze it. I don't think it's that hard. In every case I look at a Google aerial map, high resolution. You see the roads, you see the topography, you see the land uses, you know what the zones are, and you do it, and then that focuses the tribunal on the area in question. And my objective here today, of course, is to win my case for my clients, but my other objective also is to advocate for a proposition that allows for the efficient resolution of these cases, because we get tied up in these knots in these cases, and that process is time-consuming, it's expensive, and results in appeals. And I just think that if you look at the jurisprudence requires it, it makes sense to require it, and it will help streamline the process.
I want to be sure I understand, though, what specifically you would advocate for as a definition, to use your word, of neighborhood for purposes of the special exception. Would you import whole cloth what we have said in zoning matters? Would you refer to as principles, as I think earlier?
The answer is yes. In fact, this court has already done that in the Holbrook case, where this court in Holbrook, a special exception case, relied on the rezoning jurisprudence to define the neighborhood. And so I think that the answer is yes, because in my mind, the notion of a neighborhood, I'm speaking as an advocate, and someone thinks about it and cares about it, the notion of a neighborhood it applies to all land use and zoning. For reasons I can't totally explain, that it's been refined in the rezoning jurisprudence. It's implicit in the special exception jurisprudence. Albiani touches on it in the variance jurisprudence, but it's not spelled out with precision the way it is in the rezoning jurisprudence. And I think, yes, there ought to be, in each of those areas, there should be an obligation to define the neighborhood. And I think that the court, it would be appropriate to rely on the rezoning jurisprudence and apply it to the special exception cases.
The Court of Special Appeals has issued an opinion in Lucas in which they defined in a special exception case what the description of the area should be. And the Court of Special Appeals held that the description must be precise enough to allow the court to comprehend the area that the board considered. should we adopt that standard?
Right. One of the ironies of this case is Mr. Barheit and I were in the Lucas case, and yeah, I do. I think that that's a reasonable recitation of the law. We also cited our papers another Court of Special Appeals reported opinion where they couldn't find the authority. We cite that in our papers. So there's uncertainty in the Court of Special Appeals. There's certainly uncertainty in the administrative agencies across the strait. But yeah, I think the Lucas case is appropriate. So I'll save my remaining 10 minutes. Thank you.
Thank you, Mr. Nelson. Mr. Barheit? Did I pronounce your name correctly, sir? Barheit?
Yes, you did. Thank
Is
you
that
very
right?
much.
Okay.
Good morning.
Good morning.
May it please the Court, Scott Barheit and Adam Baker, who assisted on the brief. Thank you very much for this opportunity. I'd like to get right to, if I could, answering some of the different questions that the panel asked about. And first, with regard to the burden, we were not dealing with a case here in Baltimore County where we're up at all wee hours in the morning trying to try this case. We're in front of a panel of three, two of whom were attorneys, in the middle of the day. I was well rested. I think they were as well. And we went on for a couple of days, and they had ample opportunity to review briefs. And at the very beginning of my comments, at the beginning of the case, I unequivocally stated, as Mr. Nelson points out in his brief, that we have the burden of proof. And we also had the burden of going forward. We began the case by identifying all of our witnesses and putting them on the stand for direct and cross-examination. He also had an opportunity to put on witnesses. And I think that the administration of the case was exactly as Judge Murphy suggested in his concurrence in the Loyola case, in that there should be clarity about who goes forward, who goes first, who bears the burden. I said right at the outset that we did. So part of the point here is that there really is no dispute as to what the law is. The law is clear. The way in which we practice is clear. We, as the petitioners, go first. We have the burden. I've never asserted otherwise. None of our pleadings assert otherwise. And we believe that we met that burden. Now, what I think really gets to the hub of the matter is really a semantic question about the meaning of the words that were used by the Board of Appeals when it wrote its decision. And in that question,
Excuse me, is it a confusion relative to burden of proof as opposed to burden of persuasion relative to a specific presumption?
I don't think there's any confusion whatsoever at all. When I either in terms of how we present the cases or how the cases are analyzed by the panels, it's clear that we go first. If there are material disputes of fact, that's up for the Board of Appeals panel to wrestle with. Here they did that. It's clear that they understood what the factual disputes were in the way they wrote their opinion. And so I don't think that there is any confusion. But what I think Mr. Nelson is trying to assert is that somehow, taken out of context, a particular phrase means something other than what it means. And that phrase, in the context of the entirety of the Board of Appeals decision, was reviewed first by a Baltimore County Circuit Court judge who did not read it the way Mr. Nelson reads it. He read it the way I believe that the Board intended it to be read. It was later reviewed by a panel of three at the Court of Special Appeals who also addressed specifically in their decision the assertion that Mr. Nelson makes about the confusion of the language, which they found not to be confusing. And if you look on page 5 and 6 of their unreported opinion, you'll see that they directly addressed that question. And it's clear from their interpretation, again, it's a question of what did the words mean that the Board of Appeals used, not is there really a question of law here. There's no dispute about that. We all know who has the burden. But did they say the magic words in the right order? Did they say the right words in the right way? And the Court of Special Appeals goes through its analysis and makes it clear that when you look at the Board of Appeals opinion in its entirety and in the context of how the case was tried, they make it clear that they acknowledge that we have the burden of proof, and they acknowledge that we met that burden. When you look on the decision section of the Board of Appeals decision, and it's the quote that was earlier referenced, the instant case then presents the narrow issue of the petitioner's compliance with requirements for a special exception on the top of page 6 of the order. In the board's view, the evidence presented is sufficient to satisfy the requirements of section 502.1. It just seems to me that you either read this one way or you read it the other. Every judge that's read it so far has read it in the way that the petitioner asserts is the way that you should read it, that the Board of Appeals understood who had the burden and that they looked at the evidence. You can tell by the preceding 4 or 5 pages that they understood what the factual questions were. They just happened to agree with our assertion that we had met our burden.
Counsel, on page 6 of the Court of Special Appeals, unreported opinion, the panel discusses this language.
Yes.
And it says, the board is referring not to the burden of proof, but rather to the presumption of validity once the applicant has already presented sufficient evidence. I'm not sure I understand what this phrase is, the presumption of validity.
If I may, I think you have to read the rest of that paragraph where the Court of Special Appeals panel clearly says the board is merely emphasizing that the protestants have failed to rebut the evidence put on by the applicant. So when that
I'm sorry, the rest of the paragraph, you mean the earlier part of it?
No. You had read on page 6 a portion.
Oh, I see.
But I think you have to read
sentence.
the next sentence. I think you have to read the rest of that sentence to see what they meant in that paragraph.
I just don't understand what the presumption of validity once the applicant has already presented evidence. What does that mean? If they meet their burden of production, then there's a presumption in their favor?
Well, I have to admit that I can't read their mind. I'm not 100% sure what they meant when they read it.
So you have the same question I do.
So I do, in the sense that you have to ask yourself, okay, what was the board trying to do? Did they understand the law? Did they understand they were applying 502.1? Did they understand that there was a burden of proof and who had it? Did they understand what the facts were as presented? I think that's clear that they did all of that. And I think it's also clear from their order that they understood that we had the burden and that we had met it, that the evidence was sufficient. I also believe that the Court of Appeals... It
appears as if the Court of Special Appeals didn't understand or doesn't agree with Judge Murphy's concurring opinion.
Well, they don't address Judge Murphy's concurring opinion in the fashion that Mr. Nelson has asserted to you here today. But what they do say, again, I think, is how they read it. The board is merely emphasizing that the protestants have failed to rebut the evidence put on by the applicant, and that makes sense to me. I think that's what they're saying.
The Court of Special Appeals quoted the board's use of the word presumption in another instance. This comes from the excerpt of page 542. The board stated, as noted above in this opinion, there is a presumption under Maryland law that a special exception is in the general interest of the jurisdiction and therefore valid, and that the special exception is properly denied only when there are facts and circumstances showing that the adverse impacts of the use at the particular location in question would be above and beyond those inherently associated with the special exception's use.
Yes.
Now, the Court of Special Appeals quoted this.
Yes.
And then right after that, in the board's opinion, is where the board makes the statement that the protestants have not rebutted the presumption. So it appears when you read this that the presumption that's not being rebutted is what the board is referring to in the quote that I just read. Would you agree with that?
Yes, I think the Court of Special Appeals got it right, that they're emphasizing they failed to rebut the evidence put on by the applicant. Yes.
Is there any dispute that what the board wrote about this presumption under Maryland law concerning a special exception being in the general interest, that is an incorrect statement of the law.
No, we are certainly not asserting that, and I don't believe that Mr. Nelson asserted that either. Because, for example, how would you try the case? If there was truly a presumption in the sense that we didn't have to put on any evidence at all, what would happen when the tribunal started the case? If I walked up and said, "Good morning, I have a presumption, I'm done, Mr. Nelson, take it away," that's one thing. But that's not exactly how these things happen. So there is a presumption that you carry with you when you're starting the case, but you still have to meet your burden of proof. You still have to tell them something. What is it that you're doing? What is the impact? What's going on? What are the possible issues that might arise? Mr. Nelson gets the full opportunity to present all of that as well. So part of the whole presumption issue, and we struggle with this sometimes because one of the things we talk about is, well, how much are we going to put on in evidence during our case in chief, knowing that we have a chance then to have a rebuttal case? And we have to make a strategic decision about, well, do we put everything on in the first part of the case and wait and see if anybody complains? Do we do just enough to let the trier of fact understand because we have this presumption in our hip pocket? And I think you'll see from the transcript that's not what happened here. We actually did move forward in its entirety of trying the full case, identified all of the issues of which we were aware, and we didn't wait for Mr. Nelson, by example, to put on his traffic expert. We knew what was happening. And so I believe that the presumption issue is one that often causes confusion when you read it out of context, but it's really, I think, more of a guide to the attorneys who are trying the case and then the panel who's trying to decide in the context of the evidence being presented, what does that presumption mean?
So we're struggling over the construction of the board's opinion and the context in which the board is using or referring to the presumption of validity. Would a remand be appropriate?
Well, I have to speak against it, obviously, because we've been at this for multiple years, and it's only going to mean we're going to double or triple the amount of time that we're at this, which is clearly burdensome to my clients. And in a situation like this, where this is really about competition and the effort to forestall competition, I would suggest to you that's not the thing to do. But getting to the actual words and the situation presented, I believe truly, and I believe that the Circuit Court agreed and the Court of Special Appeals agreed, that we did meet our burden, that the presumptions were properly applied, and that the board did understand the law. Was it perfectly recited? Could I have written it better? I would like to think that maybe I could have written it better, but I believe that when you read it, you understand what the board was trying to do. You understood that the board did place the burden properly. And it's not like I was trying to get away with something here. We did not sit back and say, oh, he has the burden, have at it. That's not what happened here. I think if those were the kinds of facts that had been presented to you, I might have a harder time arguing. But that's not what happened. That's not the facts of the case. If I could really quickly talk about the neighborhood issue. 502.1 does not require a specific delineation of the definition of neighborhood. In fact, it uses the word locality. So the statute does not require it. Baltimore County Council knows how to require you to define neighborhood. It does so in the context of compatibility analysis. The case law clearly does not at this point require a specific delineation of the neighborhood where you would identify a map and draw a line and say, on this side of the line, you're in the neighborhood, and on this side of the line, you're outside of the neighborhood. That's clearly not required by the case law. That is what Mr. Nelson is suggesting.
Is that what they do in the variance cases?
Not in Baltimore County.
I'm sorry, not variance, the change.
Yes. You do it both in there's two contexts where it happens. One is compatibility and one is in a reclassification case. And it's because you're asking a different question. You've anticipated my next argument. In both of those cases, you're having to actually make a comparison a factual comparison between two things. In both a compatibility question and a reclassification question, you're saying, define the neighborhood and be specific, because we're going to ask a particular question about that neighborhood. In a compatibility, you're saying, is the architecture that you're proposing, to oversimplify, is the architecture that you're proposing similar to what's in the neighborhood? Yes or no? In the reclassification case, you're saying, okay, you have to meet the burden of showing a change in the neighborhood. So let's define it in a point in time. And then you're going to have now the burden of saying, and here's how it changed. Unlike a situation where, in a special exception, the real focus of the case law is on where's the harm and what's the adverse impact. And I would assert that you don't stop at that line and say, I'm sorry, that noise, traffic, environmental impact, whatever it is, because we've defined the neighborhood here, which might be on one side of the street versus the other, well, now we're going to stop at that line in determining what the impact might be. That's just silly. There's evidence presented about what the impact might be, and you follow that impact where it takes you. Different impacts are different. Noise might be one impact. It might only go a certain distance, but maybe there's flooding impacts that are much larger and much broader or go in a completely different direction. I would assert that the basic premise of the special exception standard is you define the adverse impacts that are inherent in the use. Then you look at this particular site and say, what are these adverse impacts that are actually predicted here? What do we think is going to happen in fact? And you make a comparison of those two, and you follow that impact where it takes you. I would assert that what's going to happen if you decide today to change the case law and require a bright line is that we're going to have a new set of litigation over, well, where was the line drawn? Did we draw the line in the right case, in the right place? When what we should be asking is, what's the adverse impact, and is it more than you would ordinarily expect? And not be arguing about whether you stop measuring it at some hard wall someplace. Follow it where it takes you. Some of the impacts are going to be more narrowly wandering around, and some are going to certainly be greater in the geographic area where they might impact.
Do you think the standard set forth by the Court of Special Appeals in Lucas is an appropriate standard for defining the area?
Well, it's interesting. We did try that case together, and ultimately, in Lucas, I lost that case because I was not able to convince any of the appellate courts that we were an airport, and that was how they actually decided the case. They did not actually make a decision about whether the Board of Appeals properly defined the neighborhood. And what I was arguing there related back to the impacts. Part of the language of the Board of Appeals decision in Lucas looked at impacts that they were asserting occurred in an area that in some cases involved almost all of Baltimore County because they were saying other RC2 zoned areas. And so I was trying to assert that it was nonsensical, that it was virtually impossible for my little airport to have an adverse impact in these areas that were so far away. As you know, I lost that case, and not on that issue, ultimately. It came down to the airport issue. But that's what we were trying, that's what I was trying to assert. I was not trying to assert that there was a defined boundary of a neighborhood and you weren't allowed to step across the street. I was trying to say, you can't say there's an adverse impact on all of the RC2 zoning. That's all over the county. How can you base your now I'm getting all worked up about having lost that case. But
the point is, I agree with you.
You never let these things go.
Some are hard. Some are hard.
I agree with you.
Congratulations, a good win.
The court did not hold that the board is required to define a neighborhood.
Correct.
I certainly agree with that. But the Court of Special Appeals definitely observed that one definition of the area would be that the description should be precise enough to allow a court to comprehend the area that the board is considering. What I'm asking is, do you think that's an appropriate standard?
I think it is in the context of the question that's being asked. And what's the question? It's really the question of Schultz and 502.1. What's the adverse impact, and is it any greater than you ordinarily expect? As an example, one of the adverse impacts that was asserted had to do with traffic and specifically turning movements of a truck at the intersection of Groff Lane, which doesn't exist yet in its current configuration, and Reisterstown Road. It doesn't take much to figure out what that area is of impact. It's right there. So it's clear that they understood the area that they had to review in that question. The other question had to do with crime and economic impact on the competitors across the street and immediately adjacent. You know what you're talking about. You're talking about right across the street. Another had to do with the question of need and how the statute triggered us. We had to, thank you, we had to identify within a mile away how to answer that question. So to summarize, I think that the impact determines the area in which you review. Thank you very much.
Thank
Appreciate
you.
it. Great pleasure.
Mr. Nelson?
Sorry, yes.
Here's the court. We briefed before the administrative agency our theory about the neighborhood. We briefed before the agency our theory about Judge Murphy's concurrent opinion. These were papers that we filed and were before the board. And my clients disagree with the assertion that the board assigned the burden to the applicant. And here's how I see it. There was competing evidence on each of the issues. The applicant presented evidence. We presented evidence. And if this were a summary judgment case, there was substantial, or there was evidence in support of either side's point of view. That if a tribunal had found facts in favor of one party, it could be defended. If they found facts in favor of the other party, it could be defended. There was competing evidence. So the question is, how do you evaluate the evidence? Who has the burden to prove? And we say the board erred because it looked at the competing evidence and said the citizens, protestants, have the burden to prove, when they should have said the applicant had the burden to prove. So with that prism, they said the evidence presented is sufficient to satisfy the requirements of 502.1. I'm looking at extract 542. In the board's view, the evidence presented is sufficient to satisfy the requirements of section 502.1. The board doesn't say to whom they assign the burden when they reach that conclusion. The sentence is written in the passive voice, the evidence presented. It didn't say whose evidence. It's in the passive voice. And it doesn't address the burden. And then at the bottom of 542, it offers this language. There is a presumption that a special exception is in the public interest and therefore valid.
You're on 502?
I'm sorry, 542. I beg your pardon.
Oh, I'm sorry. My bad hearing.
542, this extract. This is the central page of the... Okay, so, Judge Act, I was at the top where I was reading the sentence. In the board's view, the evidence presented, it's written in the passive voice. It said the evidence satisfies the requirements of 502.1. The board doesn't say to which party it assigned the burden of proof. And then lower on page 542, the board says there's a presumption that a special exception is in the general interest of the jurisdiction and therefore valid. That informs, I believe, to whom they assign the burden of proof. And then the next paragraph, I think, eliminates any doubt. The protestants' concerns, now they're talking about my client's evidence, taken from the available evidence, do not rebut the presumption of validity. I don't think there's any question but that they assign the burden. Now, it's interesting but irrelevant that Mr. Barheit said that, told the board that his client had the burden. What's relevant is to whom they assign the burden when they evaluate the evidence, and I think that the only answer is they assign the burden to my clients. On the section, on the question of the neighborhood, council alluded to the word locality in section 502.1. We briefed the cases. Locality is a synonym for neighborhood. We've cited all the cases, appellate cases come out of Baltimore County where they use those two words interchangeably. So I don't think that's a powerful argument. I will also note that I think the requirement under Schultz to define the neighborhood is a common law requirement that exists without regard to what the particular county ordinance says. So we believe that it's helpful that Schultz requires the definition of the neighborhood. How else can you evaluate whether there's adverse effect in the neighborhood if you don't know what the neighborhood is? That's the question. That's why I believe it's implicit in Schultz and Loyola. How can you evaluate?
In your experience, have boards specifically delineated the neighborhood in special exception cases in all the years since Schultz?
Well, that's one of the things that's fascinating about my practice is I go all over the state, and there's a different culture in every county. Prince George's, every time. In the staff report, there's a detailed staff report. They define it by geographical boundary. The zoning here.
When you say geographical boundary, what do they use?
A road, for example, a Patuxent River. We cited an example in our cert petition, not in this record, but so staff defines in Prince George's County. The zoning hearing examiners define it. The district council, every opinion they have on a special exception, they precisely define the neighborhood. In Baltimore County, they don't. So that's my answer. Some do, some don't.
Mr. Nelson, before you sit down, I read your argument on the other question, not whether we should define neighborhood, but on the larger question of what to make of the language regarding presumption. As I understood your argument, it was the law was misapplied in this case. The standing law was misapplied. As I read the amicus brief, it suggests to me something broader. Get rid of the presumption, the language of presumption altogether. Where do you stand on that? And is that, if I have interpreted the amicus brief correctly, is that an issue that is properly before us?
I think the amicus brief is broader than my position. I'm not saying it's not correct, but when I'm doing a cert petition, I try to draft the issue as narrowly as I can draft it. And I was trying to reconcile these concepts. The applicant has the burden. There's a presumption of validity because it's a special exception that the legislature has decided is permitted if you can meet certain cases, certain conditions. So I view the presumption as it's allowed so long as you meet the test for a special exception. Mr. Zimmerman, on behalf of People's Council, I think persuasively, I was persuaded by it, that the presumption really doesn't belong in the jurisprudence at all, because there isn't a presumption. What's in the law is that a special exception is a use that the county council or whatever the legislature has decided is allowed in a zone so long as you can prove your case for a special exception.
Mm-hmm. And so bottom line for you is, with that being the law, it was misapplied here. That's your... I don't want to put the words in your mouth. That's essentially your argument.
Yeah, I would say it this way. There was competing evidence presented by both parties. Every issue was in dispute. Under the Judge Murphy concurrent opinion, if there's a genuine question of fact, which there was, the zoning tribunal must assign the burden to the applicant. The board did not do that in this case. In fact, it assigned the burden to my clients. And we think the appropriate remedy is to vacate and remand with instructions to properly evaluate the evidence in view of the correct burden of proof, and if I'm successful in the neighborhood issue, to define the neighborhood. So we ask for a vacation and a remand for a reevaluation of the evidence with the correct application.
Was the failure to define a neighborhood material to the outcome of this case?
Actually, it was not central to it.
Did I hear you
Material,
say
material
not
is-
central?
In this case, it was not.
Okay, not even.
In other words, the answer, in this case, no, but it was an issue we presented, but Judge Atkins, no.
Thank you.
Thank you.
Mr.
Thank you.
Nelson, I just want to be clear on the issue regarding Judge Murphy's concurring opinion.
Yes, sir.
Are you stating that you believe Judge Murphy in Loyola is taking the law in a different direction?
No, I think that was an illustration of the fact that Judge Murphy's background was in the trial courts, litigating summary judgments, and I think he was using, and his analysis was informed by that. I think it's a good explanation of the law. It's a more precise explanation, and it's one that we can all read and understand and apply.
All right.
He's most articulate. He's the most articulate, but he's just restating what the law is.
Give us a short answer to
The
the
answer
board's
is
question.
yes.
Thank you.
That was
Thank you.
perfectly succinct. Thank you, Mr. Nelson. Thank